Hello and welcome to your Hometown Solutions. I'm your host, Jean Newell with Waterview Realty. And in the studios with me today is Jonathan Lack, my co-host. Hello, Jonathan.
Hi, Jean. It's great to be back.
And Jonathan, tell us a little bit about what your specialty is. Oops, can't say specialty, right? What your focus is on real estate and law.
Yes, my area of practice with Lack & Lack Chartered is transactional real estate law.
I just found out. I cannot say specialty. So that's good. Do you have a focus on real estate law? And you also own Waterview Title and Waterview Realty, so we can talk about real estate in terms of that as well.
Yeah, the goal at Lack & Lack Waterview Title, Waterview Realty is to be able to cover all of your real estate needs. So
that's
if you're
right.
Buying, selling, have any issues with real estate, feel free to give us a call at 321-953-5115, and we'll answer any questions you may have.
That's right. And for those of you listening today, we're going to be talking about part 2 of elder care. And we have in the studios with us again from last week, David Slodum from the Slodum Law Firm. We had a great show last week, and we talked about all kinds of probates and wills and everything that you didn't know that you needed, but it's very important. So today we're going to talk more about guardianship and some of the other issues that come up as far as Medicaid and so forth. So welcome to the studios again, David Slodum with Slodum Law Firm. Hello, David.
Hey, thank you. I'm glad to be here again.
Well, we're going to have a next 20-25 minutes all talking about the different things that people need to know. And you have some great information on your website. Go ahead and share that with our audience, your website and your information on how they can contact you.
Sure. So the website that can be accessible anywhere you can find the web is slonimlaw.com. That's SLONIM law.com. And the Melbourne office number is 321-757-5701.
That's great. Well, you have great information on your website, and I know you like to focus on the various things that have to do with elder care, like estate planning, probate, Medicaid planning, guardianship, digital estate management. We touched a little bit on a digital estate management, and that was a very interesting topic. And I'm not too sure we actually kind of finished that up last week. Was there some more that you wanted to add on digital? In fact, go ahead and let's review what digital planning is.
Sure. So basically, digital estate planning or management is something that's kind of coming into increased focus now that we have so much of our lives online. I tend to call it virtual reality because, we have that virtual world that's coming into our real world more and more often, especially when we're talking about our Teslas or, Internet of Things or other things like that have online accounts, but then we interact with in the real world. And so digital estate management is for any of your online accounts that don't necessarily have a beneficiary designation opportunity like your bank accounts do, to be able to transfer or close those accounts when you pass away. And so that becomes increasingly important when you have more utility bills and other things that are coming into your email that need to get transferred. Also, a big problem that we're seeing is for your Facebook account when there's a lot of nefarious people that are coming on when a person passes away and opening up a GoFundMe account or something else allegedly for the benefit of the deceased or the family, and then people donate to that and they abscond with the money. Mm-hmm. So this is something that we see an increased fraud situation, and so it's important to have immediate authority to be able to close those accounts. And the problem is that these accounts stay active for who knows how long after you pass away, depending on which account it is. So I could go on for more than half an hour on that. So,
well, you had said last week about a computer, and someone had to get into their parents' computer or relatives, family members' computer, and they didn't know the password. How do you have to take it to a specialty shop, or do you have to get permission from the government? I don't know, to get into someone's computer. How do you get into it if you don't know the password?
Well, usually just ask your 11-year-old, and maybe they'll be able to do that.
The 13-year-old.
Hack into your computer. Right?
Yeah. But actually, the interesting thing is that there's federal laws that prohibit even a spouse to be able to access your online account. So, and people have actually been taken to court for doing that and have been fined large amounts of money for accessing your others. So, if you say, oh, well, I've got a list of these logins and whatnot for these accounts, and I'm just going to give it to somebody when I pass away, then, you are, in a sense, violating federal law. And so, there has to be other ways of doing that. And one of those ways is through making sure that your last will or your trust or the power of attorney or the guardianship papers, if necessary, will have special magical language in there that is going to allow that agent to be able to act on your behalf for the digital assets as well. And most elder law or attorneys that create a will just because it's not something they normally do may not have that special language in these documents there. And it's important to go to somebody that's well versed in that to make sure that everything is properly done.
That's one of the reasons I love having this radio show, because we get to learn new things. And even though I've been in practice for pushing 30 years now, these are new areas of the law and new developments that are happening. And it's important to stay up on these topics. And Jean, thank you for having the radio show to enlighten our audience for it. With that said, my question to you, I just lost it.
It was about digital.
The question, I guess it had to do with the Facebook accounts.
Oh, yes.
And I remember reading just a couple of years ago with Facebook ended up having some big to-do, and they changed their policies to allow for this post-mortem access and such. Is that something tie into the other question that was on my brain that I had forgotten a second ago, which is the will the proper place to put this clause that gives access, or would there be some type of pre-need declaration that you would do it?
Yeah, I love that question, and we have about 20 minutes here. So let me give you just try to do like a 30-second overview of what we're dealing with here with digital assets. So Chapter 740, under Florida law and RUFADA in general across the United States, says that there's basically 3 tiers. So first, you can have an online tool that you can set up that's going to have a representative that's going to be the authorized person to be able to access or close those accounts. And if you fail that approach, then you have to have your estate planning documents, your will, trust, power of attorney, guardianship papers that are going to have special language in there. And failing that, then it falls down to the end user license agreements that we all read and understand of every single website out there. And the problem is that most websites out there don't have any language at all regarding what happens to your information after you pass away. And so if there isn't anything there, then there's a real big question as to who has the actual authority to handle your data. And one thing people don't realize, just as a bit of an aside, is that for your Amazon ebooks, for example, or your iTunes music, those are licensed to you. So when you pass away, you don't own that data there, as a little aside.
Oh, that's interesting.
So, when you pass away, that data goes back to those companies. And so you can't keep that for the kids' use, for example. But, people have all their photos. We take so many photos online now that are on our phones and get uploaded to the cloud, or the digital documents that we have. Those are all online. And so nobody has photo albums that they pass along anymore. And all this information has the potential of getting lost. And then you've got the financial accounts that are pretty much all via app now. That PayPal has a huge thing that you can do. There's lots of different Venmo and etc. And these are all online, and you can do your stocks that are only online. You don't have any way to kind of reach a real person, and these are all without beneficiary designations. And so the problem is, again, when you pass away, then what happens to those real dollars that that person's going to have there? So it's a real emergent field.
Well, like you said last week, that people don't necessarily like to talk about passing, and they don't like to bring that up necessarily. We know at your dinner table it's brought up all the time.
Yeah,
but
we have a countdown to death here, about 30 seconds usually. Yeah.
But most people don't like to talk about it. But you had a great idea. Give your parents a certificate. What did you call it? A free certificate?
A gift certificate?
Gift certificate to come in and have a free consultation, because that might be exactly what they need to do. But, it's sometimes difficult to say, tell me, Mom and Dad, all your assets, because it sounds a little strange.
Right.
And and people don't like to talk about it because they think it's some bad luck or something. I don't know. Everybody has their own opinion on that. But if they could come in and just have a free, is it a free consultation, or what do you charge for a consultation?
Well, I always believe that you sometimes get what you pay for, and you never get what you don't pay for. And so I do charge a consult rate of about $150, but that's credited towards an actual work that we do. So basically, if there's just nothing further other than a consult, then you're getting some value for what you're paying for, and then it's if we do some work, some of the estate documents and whatnot, then that goes towards that. So
I don't think people realize what benefit there is to sit down with someone and discuss, because you might not even be thinking. I had written down PayPal before you talked about it, because a lot of people have their own little PayPal community. They might have an eBay account. They might have all these different things, and it's continuing to keep churning out if they've got things for sale on eBay and all those kind of things. That the children don't know what's going on, and they don't know about a PayPal account going into a checking account. I mean, there's so much that we rely on digital.
Dating sites is a big thing, actually. We kind of all laugh and giggle about that, but somebody may not want those accounts to be active when you pass away.
Exactly.
And that's something that's kind of a big thing right now. Also, aside from that, your Netflix account or other things, because you may have a Netflix recurring charge on a communal credit card that you and your spouse may have, but that account is only for that one person, not for both. And so again, we may want to make sure that that's going to be terminated appropriately then.
You bring up the new laws regarding it, and you said it was Chapter 740, so I will be reading that. But since most of the audience probably would not do that, is there, I guess for lack of a better term, an intestate succession type law? And again, for those in the audience, when you die with a will, your testate, meaning you have stated what you want to happen to your stuff. The state of Florida has what's called intestate succession, where if you don't do a will, the state of Florida has determined what will happen to your stuff, typically spouse, then kids, then parents, etc., but it can vary. So if somebody doesn't have these digital rights name, does the intestate statute account for that, or is the legislature not that far along yet?
So that's where that third tier in the 3-tier system is going to come in, and basically it's going to end up with the end user license agreement governing. So there's nothing in the statute that actually says a particular person will have the automatic authority as if a person would in an intestate situation where you have a kind of a list or tier of people. It's not that way for the.
So if you don't attend to this, then you're leaving it up to chance what's going to happen to your digital rights. Right. And it's a fascinating area that is definitely new, but that's where the world's heading. There's always going to be something new, and again, that's what makes these shows so interesting. Yeah,
I recommend people go to estatepass.com, for example, for a good service that's going to help with that.
Oh, very good.
Well, you've been listening to part 2 of from our elder care. We were on last week and talking about this in more depth of David Slonim. And we'd like to remind you that if you would like to catch part 1 and that you didn't hear last week, you can go to talknetworkradio.com and go to the archives page, or to our page, Jean Newell and Jonathan Lack, Your Hometown Solutions page. And there we have all of our digital, I always say recordings, but I guess we can't say, can we still say recording? I still say recording. I still say tape. We don't use tape or recording or anything, but whatever. They're all there for your listening pleasure. And we've got them all named. So if you want to go back a year and a half, we've got all kinds of interesting shows there. By the way, if you would like more information about what you've heard here today, David Slonim, give us your information on how they can contact you or go to your website.
Sure. The easy part is the phone number, 321-757-5701. Or the website is slonimlaw.com.
And Jonathan, and you specialize in I can't say specialize, that's right, it's a new rule or something. You have 3 different businesses, and They tend to focus on real estate. Let's put it that way. Is that better?
Yeah,
I don't know what
really
to say
struggling
now.
with this, but that's okay. Yes, we are a real estate law firm, title insurance company, and real estate company, and actually title insurance agency if we're going to be particular. And I can be reached at area code 321-953-5115, or our real estate website is waterviewre.com.
We always have to comply. When we have Carolyn Wolf on from Certified Mortgage Planner, she always has to give her license number. So we want to make sure we comply with all the governmental and federal things and rules and regulations.
Two attorneys in a room, and that's never a good idea.
Yeah, I get three opinions, right?
There you go. We were talking last week a little bit. We touched on durable power of attorneys, and again, my lament that the springing power of attorney doesn't exist anymore. But moving on from that, the conversation with the durable power of attorney, when somebody doesn't go through the process of pre-estate planning and pre-need situations and therefore don't have a durable power of attorney, and then one of their loved ones becomes incompetent, I guess the only alternative at that point is guardianship. Is that correct?
Yeah.
And
so, go ahead.
No, I was
okay.
going to say you practice in that area. Give the audience a little 20 seconds on her
Sure.
on guardianship.
Yeah. So, so I'm in front of a judge that says that attorneys can't even give their name in 15 minutes, let alone explanation here. So, basically, with a guardianship situation, that comes into effect when there is no named person to be able to act on a person's behalf if you're incapacitated, or even if there is a power of attorney in place, if the person is acting in such a way as to prevent the agent that's named in the power of attorney to do what's right for the person. So, an agent through the power of attorney can again act on a person's behalf, but they can't remove a person's rights. And so with a guardianship, that is something that is the most restrictive means that the state has to kind of govern somebody, because it's taking a person's constitutional rights away. And so with a guardianship, we are taking a person's rights to marry, to vote, to contract, to drive, and a wide variety of other rights that are being taken away from a person because they don't have capacity to do that anymore. They could be a harm to themselves or others. And so the bottom line is that if there's no power of attorney or healthcare surrogate in place, then that requires us to go to court for this procedure. And that is oftentimes a very strenuous process for both the alleged incapacitated person and also for the family members. And so it's also significantly much more expensive than a power of attorney or a healthcare surrogate, where you can get those for almost nothing or a couple $100. A guardianship is generally going to cost the alleged incapacitated about $10,000, give or take, for that whole process to complete. So it's much more a good return on investment, talking about financial people, if you're doing this power of attorney or healthcare surrogate up front, rather than having to wait for a guardianship to do all this stuff.
I find in the conferences I do, and again, I do very minimal, so don't step on your toes on these estate planning, but the occasional conferences I have, first of all, I hate those conferences. I am like everybody else, not wanting to discuss all of the bad things that will ultimately happen, but they're necessary, and everybody who's listening should give David a call, or at least some estate planning attorney. It is very important to go through the discomfort of discussing the what ifs, because people come to me and they say, okay, well, we just want a simple will. We just want it to, when I die, I want to go to them. Well, what happens if they die before you? Oh, well, what happens if the kid dies before you? Oh, I hadn't thought about that. Mm-hmm. And all of a sudden in the estate planning conference, we're fleshing out all of the different, very sad and unfortunate scenarios that we hope will not play out, but you have to account for them if you're going to do your job, David, and if I'm doing my job, and if people are being honest with themselves, they need to really think about what they want to happen when bad things happen. Mm-hmm. And the durable power of attorney is an incredibly useful, powerful document that prevents the need for this guardianship. And I didn't realize, I knew it was expensive and I knew it was a very stressful procedure, but I didn't know it was quite that costly. And what I did know is every time the guardian wants to do anything on behalf of the ward, the incapacitated, they have to go to court to get authority to do just
Right,
about everything. So suddenly you want to do something, you're going in front of a judge again instead of just acting on their behalf. So it's very important that those of you who are listening consider your estate plan. And although we call this elder law, this is not necessarily for the elderly. As David, you pointed out, the living wills, I didn't realize that either, that the court cases were all women under 40. But a living will, for those of you who don't know, is that pre-declaration that you either do or do not want to be kept artificially alive. I'll let you explain it better than I can.
So a living will creates a rebuttable presumption as to what you want to have done or not done for your end-of-life procedures. And so it's different from a do not resuscitate order that a lot of people think is the same. A DNR or DNRO is something that is only provided to you by your physician. And it's a yellow piece of paper, and it's really only for CPR or for paramedics to come in to do something or not do something. And so a living will is going to allow you to state, first off, what you want done or not done for your end of life, specifically if you're in a terminal condition, end-stage condition, or persistent vegetative state, and then we kind of go beyond some of those basic categories. And also, what you want to have done for your anatomical gifts, for example, if you want to donate your tissues and organs, and who you want to name to carry out these decisions. And one of the hardest things for people to even contemplate is the idea that somebody else has to make the decision to use a colloquial term, pull the plug. We really don't want to do that. So the living will allows us to say what we want to have done rather than to force a family member to have to make that really difficult decision.
We've been talking about guardianship, and this has come up several times. When you do have guardianship, does that mean you have to be with the person 24/7?
No. So we've had some guardians that are remote in different states or countries even, and usually you can have other individuals or companies handling a lot of the local care, and so long as the guardian meets other state requirements, then it should be no problem for the guardian to be a remote individual.
Let's go into Medicaid, because that is the big thing now when people might have to go into assisted living and maybe there's not a lot of money left to support them in assisted living. But if you go in for, what would you call that, a Medicaid discussion or an elder care financing discussion, you need to get on. You can explain it more than I can.
Sure.
So go ahead and explain why Medicaid might be important to know about for your planning.
So my particular practice, we only deal with two very specific Medicaid services that are provided to the elderly. Medicaid covers a wide area of services that are both federal and state funded, but we handle only the what's called institutional care program, or the what used to be known as the waiver program, which is the home and community-based services program, and that's for people that are either living at home or in an assisted living facility. And so what happens is when a person goes into a skilled nursing facility, which is a nice way of saying a nursing home, then that costs about $10,000 a month, give or take. And the problem is that either you are going to be independently wealthy and be able to cover that $10,000 a month on your own, or you've got long-term care insurance. Those are the only two ways that you can really cover it without the government getting involved. And the third way is having Medicaid basically cover much of that cost. And so the reality is that while some people may not want to consider Medicaid because it's a government program or whatnot, 99% of individuals in a skilled nursing facility are utilizing the Medicaid system at that point because it's very expensive. You're talking over the course of a typical what I would call lifespan in a skilled facility is about 2.5 years, and so that's easy at $10,000 a month. You're talking about a $250,000 that you're spending just for room and board. It doesn't cover medications, supplies, or anything else like that. So Medicaid is a useful tool, and we like to call it asset preservation. We're basically looking at a person's assets, and to qualify for Medicaid, there's certain very strict requirements regarding a person's age, level of need, and whatnot. And we usually, as the attorneys, can only help with the asset side and the income side. So there's certain tests that have to be met. And so a person's income has to meet certain criteria every year. Kind of the law changes. Right now, it's about 2105 is the gross income that a person can have, and about $2,000 in assets that a person can have in non-exempt assets. And so, most people may say, well, I've got more than that, and so they won't meet the Medicaid criteria to get these services. And we can help reallocate the assets in such a way to allow for them to be able to be eligible for Medicaid. And this is all done according to the Medicaid rules. So, we're not trying to hide money or do anything else like that. It's something that is permissible, and we have good relationships with the DCF attorneys and work with them to ensure that everything is done above board, and we're making sure that we're providing services to really help the individual in need, not necessarily just to make sure that there's money for other people left over.
That brings us right into this question. My sick spouse is in a skilled nursing facility, and I have been told that I have to spend down all of my assets before I can get Medicaid. Is that true? How will I care for myself?
Right. So the beauty of the Medicaid system in this respect is that a spouse has different financial limitations than the applicant or the recipient of the Medicaid services. So, while the recipient of Medicaid has a certain limited income of about 2105 in 2017 for what they can get as gross income, a community spouse can have unlimited income and can have assets in excess of, in 2017 again, because it changes every year, of about $120,000. So, so you can, and then of course there's certain spousal diversions that can be had for a certain amount of the applicants or recipients' income to go towards the community spouse. So again, it's important to talk to an attorney versed in this to know what kind of criteria and rules are available.
Right. One question that comes up in my real estate practice frequently, and I always refer them out because I don't know the answer, has to do with what I've heard as the look-back period.
Right.
So I guess I'll let you explain the look-back period better than I can bungle it up.
So now the look-back period is a 5-year period that basically is for any gifting or other transfer of assets. And that includes putting money into an irrevocable trust that'll incur a look-back period or any gifting. So, one example that I have is a gentleman that was caring for his spouse that he knew needed to get Medicaid. And so he gave a bunch of money to his church, about $25,000, in anticipation of applying for Medicaid. But the problem was that we had to report that $25,000, and that became a penalty. And so the penalty doesn't incur when you give the gift, but it occurs when you actually apply for Medicaid. And so then there's a divisor that kind of changes on a yearly basis as to how much of a penalty period you're going to have based on the amount of money that you have given during the look-back period. And so, there's again, we don't have enough time to go over all
we can't go all of it, but again, bringing it back around to the real estate, because that's my area of practice and what the show tends to focus on, is how it affects real estate. And again, I'll have parents come to me and, in this pre-planning need, and they'll maybe want to gift it to their children or adding
a child to the property is a gift.
So that is deemed a gift, and therefore wouldn't, unless 5 years passes, it would become a problem during the look-back period with application with Medicaid?
Yeah, because Medicaid says that anything that's done like that is whether or not it was intended to be so, it's a quote, in anticipation of applying for Medicaid, whether or not you really planned for that to happen or not. You may not plan it 4 years out. You may not really think about that, but it so happens. So sometimes we need to get an affidavit from the attorney saying, no, that was actually not done in anticipation of Medicaid, and then it could be okay. But there's a lot of things that can come up like that.
That's another reason why they should start planning now and getting all of these different trusts and everything lined up, because they don't know what in 5 years is going to happen. You need to line it up now.
Right.
So you don't have to worry about that.
The punchline is, don't put off the estate planning conference. It may be uncomfortable, but it's absolutely necessary, and a very important part of life is dealing with these afterlife circumstances.
Yeah.
one more time give out your information, Mr. Slonim?
Sure. It's, well, my name is David Slonim. The law firm is the Slonim Law Firm, and the web address is slonimlaw.com, and that's SLONIM, and the phone number is 321-757-5701.
Says on your card here, assisting families since 2005 in estate planning, probate, Medicaid planning, guardianship, digital estate management. We covered a lot of things in the last 2 weeks, and we hope you'll come in next week, and we're going to be discussing more real estate involvement. Jonathan, give out your information as well.
All right, Lack and Lack Charter can be reached at area code 321-953-5115 or on the web at lacklaw.com.
Thank you, David Slonim, for joining us last week and this week. And we also have our website that you could visit and see more information about our shows, which is yourhometownsolutions.com. We thank you for joining us today. Go out there and get your will, trust, probate, whatever you need. Get advice right now before it's too late. That doesn't sound right? Before it's too late. Thanks, everyone, for joining us. I'm Jean Newell.